you and I met some years back,
Yes,
back
sir.
over these issues themselves, correct?
That's correct.
Okay, well, I appreciate you coming to testify today. For the board, you may recall, my name is John Smith. I represent the appellant in this matter. You described for Mr. Siddig your role in this process, and I don't want to belabor that and go over that at a great extent, but I was a little bit hindered by, couldn't see you 100% from where I was seated. Your background, Ms. Morrison, in land use and planning, could you give me that again?
Sure. I have a degree in urban and rural planning. My first job was as a planning assistant with a multi-municipal organization. I then was fortunate enough to be hired as a manager and spent most of my time, all of my time, about 24 of my career as a municipal manager.
While you've been here in Murrysville, and in fact, we can limit it to 2008 forward, did you provide zoning advice or direction to the board when asked or when you thought appropriate?
Fortunately, in Murrysville, at various times through that period, we either contracted or had on staff community development, either a planner or a director. They were responsible for most of the day-to-day operation of the department, and were looked towards for advice. I had an integral role in managing that person.
So you were, is it fair to say you were involved in some of the zoning plans and schemes?
That's a pretty general statement. I provided advice, I provided opinion.
Okay, and that's what I think my initial question was. You provided some advice and opinions throughout the zoning process. And what I'm getting at
As it pertains to this.
Okay. And what I'm getting at is just, I want to get an understanding of your background in terms of the questions I asked you, because as you may recall, I wanted to ask some of the elected officials, and I understand the ruling, but I want to make sure that I ask you the appropriate questions, okay? From a zoning standpoint in your training, do you know whether or not Murrysville has any limitations on where it places uses in its zoning districts?
As far as whether it's a residential use or a commercial use?
Yes, in terms of, okay. Well, I think you asked me a question, so the record's clear. Do you have an understanding for, let me clean it up, for residential districts as to whether there are limitations for Murrysville to put certain uses in that particular district?
Yes.
Do you understand why there are
Yes.
limitations? Why are there limitations?
Because of the use of neighboring property right issues, compatible uses.
Is that a restriction that, or a public policy statement you just gave?
I'm not sure I understand that question.
You answered my question that you believe there was some inability to place certain uses in a residential district, correct?
That's correct.
And I think you said based on compatibility, one of the
Correct.
reasons. Is that a public policy rationale or is that a legal rationale? Do you know?
I believe it to be a legal rationale.
So there's a legal impediment for Murrysville to put certain uses in certain zoning districts.
That's correct.
Okay. And that would be true for commercial, industrial, a number of the districts that Murrysville has.
That's correct.
And would I be correct, sir, that the purpose of your zoning scheme here in Murrysville is to put like uses in the districts for which they were created?
That's correct.
So, I don't know all your districts, I know you have a number of them, but
No,
generally,
yes.
you have the business district, which is, and then you have a number of different residential districts.
That's correct.
Do I encompass all of them, other than the overlay?
Within the business district, there's a mixed-use district, and there's also a general business overlay district within the B district.
And so, when Murrysville, within these zones, complies with, in order to comply with the law, compatible land uses in like districts, correct?
Mm-hmm.
Yes, yes, sir.
Yes, I'm sorry.
That's okay. Now, you testified earlier about conventional versus unconventional wells. Do you recall that testimony?
Yes,
And you would agree with me that conventional wells and unconventional wells are two different animals.
to some extent.
When unconventional wells came to town, you believed your conventional well ordinance was inadequate to address the unconventional wells.
That's correct, based on what you were hearing.
Okay, so based on what you were hearing, you believe that those uses were different, correct?
That's correct.
And which one is more intensive, unconventional or conventional?
Unconventional.
And you believe that conventional can be placed in certain zoning districts that will be more compatible with the existing uses in those districts.
No, that's not, I didn't say that I believe, that's what the ordinance states.
Okay, so the ordinance states that. Do you believe that is a illegal proposition?
I object to any, he's not testifying as to legal conclusions.
Board sustains the objection.
From a conventional standpoint, you said that they're allowed in certain districts, correct?
That's correct.
And they're allowed in districts that have a more dense population than unconventional wells.
That's correct.
And that's not by accident, correct? That's by design.
That's by ordinance.
Okay, and by ordinance, by design. That's what the municipality wanted to accomplish.
I can't speak to what they wanted to accomplish when that was written in the ordinance.
Okay, is what they did.
That's correct.
Now, do you understand about the use of police power?
Yes.
And could you explain to me what your understanding is?
The police
But
power.
I'm gonna object again. That's certainly a legal definition of what the police powers are.
Can I receive? Sir, the last time I didn't get a chance to respond to the objection before we were ruling, just, if it's okay?
Please.
Okay. The individual's call, he testified about the legal rationale that the board utilized in making its decision and enacting this particular ordinance. I'm asking, and I've asked some basic foundational questions about his background and his understanding of zoning, because the thrust of this argument is municipality violating constitutional rights, which would include the use of the police power. I think the board has to understand whether he and or council understood when they enacted this law, the limitations, if any, on the use of police power.
I don't believe that's within, Mr. Morrison's scope of his training or his capacity, in other employment with the municipality. He's not making those legal determinations. He's testifying as a municipal manager and as a planner.
And he did testify that he, when I asked the question, yes, he understood what police power was.
I'm going to, I have a feeling we're gonna be here with this over and over again. Because what Mr. Morrison was presented as was a fact witness to just lay out the framework. He's not here as a representative to do a quasi-inquisition into the legislative determination. When you get into the legislative determination, that's at the essence of a legal decision as to whether it violates, the law. Mr. Morrison can only testify as to what he did in his capacity to bring it before the legislators who made the decision.
And remember, under your rules, your formal rules of evidence don't apply. So here, if it's relevant, I believe you can answer it.
The relevance is not a rule of evidence.
It is.
It's never, hearsay is not, if it's irrelevant, it's not relevant. That's not a rule of evidence. And he is not a relevant witness on law or on legislative intent. He's here as a municipal official that managed and presented information to legislators who made the decision. And I'll just tell you right here, with all due respect for the board, I am not placing Mr. Morrison in that. I am going to direct him, at the risk of the court saying I'm wrong, I'm going to direct him not to answer if he gets into these areas of inquiry. He is not a lawyer, and he's not gonna make any decisions or any inquiry into the legislative determination or into what the lawyers may advise the municipality.
If you read back his direct, it's exactly what he just did. He explained the rationale for what the board looked at, what the board did, what they considered, the setbacks, all those issues. I'm asking for the underpinning of that. Did he understand that, or did the council understand it? He could say yes or no.
Give us a moment, please.
The board has determined that they will overrule the objection. They will take the evidence and apply whatever weight they deem appropriate to it. They've also indicated that if the witness cannot answer the question, that's a fair answer as well. So they will allow the testimony to proceed.
No, I will get up each time where I believe he's asking for a legal opinion, and I will direct him not to answer.
Let me see if I can help. I'm not looking to be disruptive here. I just want to see if I can get an answer. Maybe if it can help a little easier. During the process, sir, were you present with any discussions about council's use of the police power in creating this oil and gas ordinance?
No.
Did you ever bring to their attention any limitations they may have with their police power rights?
Only as advised by council,
So council would have advised you, and then maybe you would have advised the board?
or council would advise the board directly.
Okay, if it wasn't in a public setting, I don't want you to talk about that because I respect the privilege. Do you recall, was it in a public setting or not?
On various occasions, yes, council was invited to the meetings to provide an opportunity for council to ask questions concerning the legal questions that they had.
And did they have questions about the limitations of use of zoning with oil and gas?
Yes,
Did those revolve around constitutional constraints that they had?
yes.
Do you recall during those discussions, and just for the record, let me back up. We asked for transcripts from the public hearing. Do you recall that?
Yes.
And you indicated that those don't exist, correct?
No, I said that they were available through the transcription service.
Okay, and do you understand when the township doesn't, or the municipality doesn't have them, correct?
That's correct.
And did you ever come to learn that the transcription service doesn't have them either? Did they take over them?
No, I didn't know that.
So just from a standpoint of latitude, I would obviously go to those transcripts and ask them questions about it. But I don't have those. I do have, and I have watched some of the hearings, which may be appropriate this time to ask that these videos be introduced into evidence of the public hearings of the first one in 2011, and I believe the one before the adoption. I think they're dated June 15th, 2011, and July 6th, 2011. And do we have the later one handed too, or no?
That's okay. That's okay.
The 2011 one?
Yeah, no, I'm just gonna object to any transcripts or any, minutes or anything having to do with public hearings, considering the adoption of the ordinance. And this is, again, a backdoor effort to get into what the legislative intent was, just overall, what was trying to be done, what the balancing was onto validity. That's a legal determination. The ordinance is what it is. That's why we resisted the subpoenas to have the legislators here. Regardless of what was considered, what was in their head, what Jim may have recommended, what their lawyer recommended, was of absolutely no relevance. The courts have been crystal clear about that. That cannot be relevant. There could have been a discussion that this ordinance is illegal all day, all night, for 20 sessions. This is what they did, and the question is it or isn't it? That's what the decision you're in, and it doesn't matter what the discussion was with lawyers as to the constitutional limits of the ordinance.
And I'm not looking for discussions from lawyers, I'm looking at the legislative history, which is relevant in any proceeding. You look at the Robinson case itself, the court went to great pains to cite the legislative history of the author of Article 1, Section 27, and how he ended up enacting that particular ordinance. So, in this particular vein, the public hearing, the reason why you have a public transcript and why they have to be under oath is so that they're available for issues like this. Here, in order to prove that they're arbitrary, we're allowed to ask questions about what they looked at. Did they act in a reasonable manner? Is it rationally related to what they ultimately did? That's something you will make the decision on. But to deny me once again the evidence as to what they did, to call into question the validity of this ordinance and the constitutional basis, how would you ever understand whether they weighed and looked at the environmental rights of the citizens if Mr. Siddick is correct and says you can't ask about that? You would never know.
How you do that, and there's only one way you can do that, regardless of the misrepresentation of Robinson, is you look at the ordinance. They could have thought all they wanted to about environmental impacts. They could think about it. Again, whenever you're getting into the legislator's consideration in their mind, and not all of it's contained, it doesn't have to be. This isn't a judicial proceeding. What went into their consideration in that vote could have been well outside the whole hearing process. They're legislators. It could have been meetings with people. It could have been going to their own classes. It could have been they worked in the industry. None of that's relevant. None of their life experiences is relevant. None of their intent is relevant. It's just the legislation speaks for itself. And they could have had the wrong intent, the wrong information, but what they came up with, that's what we're looking at. That's not legislative history at all.
Look at the exhibits that have been introduced tonight. It's all legislative history. It's what they did, when they did it, when the meetings were, what they looked at. The testimony was there was great discussions about the setbacks and they moved from X, Y, and Z. It's all legislative history. They just don't want me to ask questions about the legislative history that I want to ask about. They've opened the door. My goodness, every single part of this is legislative history. It's nothing else. What the task force did, what the board itself did. Mr. Siddick has a memo in here of what he advised the board. And then I'm not allowed to ask questions about it.
Well, how many ask questions about the process that was in?
How many public hearings were there?
How many public hearings?
Yes.
The ones that we have on video, I believe, were 2.
Well, how many were there, and where are the rest of them?
None of them exist. We've asked for the transcripts for all the public hearings. The town, or the municipality has none. The court reporting service said that they don't have them either. So I have no access to them.
Well, how can we admit only 2 of the hearings, and there may be 10 other hearings that may have discussed these issues, minds were changed, debates were held?
Well, ultimately, the hearings themselves go to what happened on those particular evenings. Maybe minds were changed, but that's not the ultimate vote. This goes back to, and I didn't have any spoliation issues. I had no obligation, nor did my clients, to maintain a printed record. That's the obligation of the municipality. The fact that they didn't doesn't prejudice me, it prejudices them. I can only give you what I have.
Well, then we're going back, the fundamental fairness, it wouldn't be fundamentally fair to put in 2 public hearings when there were many more, and the result was the ordinance. So what you have is the ordinance as to what they did.
I think this actually goes, sir, and I may be mistaken, but I think these are all the public hearings as to the first ordinance. Nothing after the second. I think this covered all as to the first.
Which ordinance is that? What's the first one?
The 2011 ordinance.
Well, then it may not be relevant at all.
It may not, but for our purposes, there are things on here that what were said by Mr. Morrison during that process.
I just don't see how it would be fair to introduce those public hearings without introducing all the public hearings, and if they don't exist, then you're relegated to the ordinance.
Well, I disagree, and I think you, in my opinion, and I respect your thoughts, if you look at any case law on spoliation, it doesn't prejudice me. It doesn't deny my clients the ability to introduce evidence when, by statute, they're supposed to have a public hearing and a transcript, and it doesn't exist in this municipality. So, I mean, I would love to give you everything, but it's within their control, not mine.
Again, regardless of whether it's transcript, record, videographer, it doesn't matter. That, whatever happened in the process of enactment, their deliberations is irrelevant. They're using it to try to establish that they can't otherwise establish through an expert or another non-legal expert what the ultimate issue is.
The board has determined that they will sustain the objection and they are not going to accept the discs into evidence. However, the board has indicated that if you have viewed them and if there is a portion of a transcript prepared and you want to ask Mr. Morrison if he was present for that or specific questioning about what he observed or anything that he said at that time, that's different.
Okay.
There's also a question with regard to the relevance of the material, because it does date back to 2011, which I believe is a repealed ordinance at this point.
Okay, and maybe I can get into some of the documents that you introduced, and it'll help clean this up next tonight. In these process, during these public hearings, Mr. Morrison, am I correct that you identified unconventional gas drilling as an industrial land use?
Yes.
And you know there's a difference between industrial land uses and residential land uses.
Yes.
Now, I'm not sure, Mr. Siddick, what you marked this yellow one, do you remember?
Yeah, that's number
That's Murrysville 3.
Okay, if you take a look at Murrysville 3, this is a document that's been accepted into evidence. This is a report of the Murrysville Marcellus Task Force of the revisions to 220.31 CC. You see that?
What page is it?
Just at the cover. I was just reading
Oh,
the cover.
yeah. Mhm.
Okay. And this is a history of what they did, correct? You have to say yes
Yes.
or no. I'm sorry.
Yes.
Not for me, I understand, just for the record. And This was in response to the Robinson Township Supreme Court decision, as the front page says.
Mhm. Yes.
And there are a number of people that were involved on this task force, based on this, I think, the second page, you see that?
That's correct.
Some of them were council people, some of them were outside people. Is that
Yes.
correct?
Mhm.
Am I correct, sir, that initially the task force did not operate in a public setting?
No.
Do you recall the general public being denied access to any of the meetings initially?
Denied? No.
Now, who was the individual that was engaged, set forth in this task force report, Alan Cohen?
He was consultant to the municipality.
Is he, is he a planning person, a zoning person?
Yes.
Both?
Yes.
Okay. And he looked at the background of Act 13, the Robinson Appeal and Supreme Court decision, correct?
Yes.
And what the municipality was looking at was, after the Robinson Supreme Court decision, how you could improve upon the ordinance, you being the municipality.
Yes.
Okay. And in 2011, you created this overlay district, understand under the auspices of the Oil and Gas Act of 1984 as to whether you even could do that, correct?
I'm not sure I understand the question.
I'm sorry, and there was a question as to, like you indicated, whether Murrysville went too far in regulating more protectively in 2011.
That's correct. I dealt more with setbacks than it did the overlay.
Okay,
I
but
don't know that, I don't recall any time that it was questioned whether the municipality had the ability to create an overlay district.
I wasn't talking about the overlay. The idea that you created an overlay district in 2011, based in part on the time in the existence of the 1984 Oil and Gas Act. That's what
That's
Murrysville.
correct.
And when the Supreme Court overturned Act 13 as unconstitutional, Murrysville engaged a number of professionals, including Mr. Cohen, to advise them as to how best to proceed, consistent with the Supreme Court's decision. Do you agree with that?
No.
Okay, what did you have me do?
There were conversations with Mr. Cohen throughout the process between 8311 and the Supreme Court decision. Mr. Cohen at various points at that time was employed as a community planner in municipalities in the area. The municipality had a relationship with Mr. Cohen, who was the community development director here when I was here the first time.
Okay, let me read you the first sentence of his report. It says, in March 2014, the municipal council authorized staff to engage me as a consultant to prepare a report on the impacts of the Supreme Court decision in Robinson Township. Does that help refresh your memory as to why he's engaged?
That was part of the reason, yes.
Okay. Now, if you look at, and these aren't numbered, Mr. Morrison, I apologize. Looks like the second textual page right there, yeah. Number 6, one of the things that he was looking at was the methods to protect the public health safety related to the Pennsylvania Environmental Rights Amendment and the responsibility of the municipality to that amendment. Do you recall that as one of his instructions?
Yes.
Now, in your direct testimony, I don't recall you talking about the Environmental Rights Amendment. Am I correct?
That's correct.
And am I correct, sir, that throughout your direct testimony here, you never mentioned once the public health, safety, and welfare when Murrysville was enacting this ordinance?
I don't know that I was asked the question.
Now, in section 3, and I think you testified, you looked at the Maryland Safe Drilling Initiative study,
Yes.
and by you, meaning you and council,
Yes, it was available
okay, and for what purpose?
to see what the hell was happening around us and to understand how other communities, in this case the state, were approaching the same issues that we were dealing with.
Do you recall whether that was an important study for council?
I believe that it was made available,
I
it was
object.
discussed.
Again, we're getting into what council would have considered. Whether it's important to council is not relevant, it's certainly way beyond his purview.
I'll withdraw that question. You testified on direct about the Maryland report was utilized by council.
No, he said it's available.
Was available. Okay, and Mr. Cohen cites it as a basis that he looked at as well.
That's correct.
And did council, or do you recall council ever becoming aware that after Maryland looked at this report, that they banned fracking in the whole state?
I don't know whether they do or not.
You're not aware of the, Maryland law that they don't allow fracking?
Yes, I'm aware of that.
Now, it says here that Mr. Cohen, this section I'm looking at the top of the next page, right before his signature, I'm sorry, you're back, it says, this section presents drafted ordinances from Peters and South Fayette Townships that were developed in response to the Supreme Court decision. I think you testified about that on direct. Is that correct?
That's correct.
It says, these ordinances are relevant as they were developed with legal assistance from attorneys who argued the Robinson Township case. Is that correct?
What do you ask?
That's what that says?
Yes,
Okay, and the attorneys that argued the Robinson Township case were myself and John Kamen, correct?
that's correct.
And those particular ordinances that are cited by Mr. Cohen allow drilling only in industrial zones. Is that correct?
I can't recall specifically what land use categories they were in.
There was an article attached to this document admitted into evidence by the new landscape of land use litigation, Robinson Township, by attorney, probably pronounce his name incorrectly, I'll spell it, Sklaroff, Michael Sklaroff, from Validity Squad. Do you see that?
Yes,
And so was this something that was also submitted to from the task force to council?
it was part of the task force report.
Okay, in this report, it talks about the Robinson Township case, correct?
Yes,
Okay, and I'm sorry, I don't mean to. And in this report, it talks about the technique of fracking doing violence to the landscape. Did you see that?
yes,
And in here, we talked a little bit earlier about zoning in your background. Would you agree with the statement in here that in you assisting in putting together the oil and gas ordinance, did you take into account whether properties could be harmed by the location of these wells?
yes.
And what kind of harm do you recall council being made aware of? Possible harms?
Environmental issues,
Like what?
water contamination, air contamination.
And do you recall where that information came from?
What information?
What you just testified to about the harm?
Various articles available through the internet or libraries, really extensive amount of information reviewed.
Okay. Now, in this section that's, I'm sorry, Mr. City.
Sklaroff.
I'm different, exhibit 3, you said?
This is true.
I'm just gonna mark it this, it said the plastic, I couldn't write it on. In exhibit 3, on page 10 of this report, it cites the, Supreme Court. It says, to put it succinctly, our citizens buying homes and raising families in areas zoned residential had a reasonable expectation concerning the environment in which they were living, often for years or decades. Now, do you understand in looking at the challenge that was filed here, that that is some of the same challenges that individuals believe that the district for which they lived, that they had expectations in?
Absolutely.
Now, on page 13 of this report that was provided by the task force, they cite the Supreme Court statement that by any reasonable account, the exploitation of Marcellus shale formation will produce a detrimental effect on the environment, on the people, their children, and future generations, and potentially on the public purse, perhaps rivaling the environmental effects of coal extraction. Do you recall seeing that?
Yes,
Okay. Did you recall council or bringing it up to council before they made a decision to enact the zoning ordinance?
this report was made available to council.
Now, if you look at the next section, this is the process of revising 2231CC. I think the next section is section 2. It's a yellow piece of paper there. On this next page, sir, it says, in this context, the following issues were explored by the task force. You see the the numbers at the bottom?
Yes,
One of them was the possible increase in required setbacks. In fact, that happened, correct?
Yes,
Why did it happen?
it was a determination of council.
But do you recall, was it based on public health? What was it based on?
Based on a number of factors that were presented throughout the public hearings and information that was made available to them.
Now, you recall, recently, one of my clients, Mr. Skiers, filed a right-to-know request, with the municipality.
That's correct.
And in that right-to-know request, they asked for information as to what council may have considered at the time, they adopted this ordinance. Do you recall that?
Yes,
And you recall telling Mr. Skiers that there was information, you just weren't sure what council actually saw?
yes, that's correct.
Now, and I think we get to the map, let me just skip. If you flip to the analysis of oil and gas drilling land use options, it's in the same section, I believe. It says there's advantages and disadvantages that the task force looked at. And again, part of the task force was, some of the elected officials, correct?
There were elected officials, yes, as members of the task force.
And when I watch at least these videos, and I do recall, I think there was maybe not an official video, but a YouTube video, you participated in those public hearings, you answered questions, you made presentations to council about the ordinance.
That's correct.
Okay. If you look at, keeping the overlay district as mapped in the original oil and gas district, one of the disadvantages that the task force found was the challenges of compatibility with residential zoning areas. Do you see that?
Yes,
So that was something that the municipality recognized, that if you kept it the way it was, compatibility was an issue because it was authorized in a residential district.
could potentially be an issue.
Does the word potentially appear in there?
No,
It says challenges of compatibility.
I'm gonna, rather not be argumentative, it says what it says. Like, I don't want him to badger. It says challenges, and that's it.
I was looking to clarify the record, if that's all.
The record is the writing, and let's not keep asking about it. We can argue this. We're taking a lot of time. The lawyers can argue this, and really, all Mr. Morrison is gonna say is, yes, council considered that. We will,
Mr. City, the board doesn't believe that there's any badgering, and they believe that it's an appropriate line of questioning, if you'd like to ask.
One of the other disadvantages of keeping the ordinance the way it was, which is ultimately what the municipality did, was a large area of the municipality would be exposed to potential drilling sites, correct?
yes,
And then there was issues of environmental impacts to surrounding property owners and sensitive land uses, if you kept it the way it is now.
the overlay district?
Yes.
That's correct.
And what were some of the environmental impacts to surrounding property owners that the municipality was concerned of, but didn't change?
I'm not sure that there was anything considered along those lines. I'm not sure I understand the question.
I'm sorry, maybe it was a poor question. When I was looking at it, one of the defined disadvantages that the task force found was the environmental impacts to surrounding property owners and sensitive land uses. And my question was, do you recall anybody explaining what those environmental consequences were? And the reason I asked Mr. Morrison is because the ordinance didn't change relative to where it's located in the overlay district.
No, there was no changes that I'm aware of. There was evaluations made, with information that was available, that there could be well contamination, there could be an impact on the air, there could be impact on soil if accidents occurred on sites. But most of those issues, when we discussed them, had to do with DEP regulating those and what our ability was to regulate those locally.
The municipality obviously believes it had the ability to regulate more than what the DEP was doing, or in addition to what the DEP was doing.
No, we did not believe that.
So you have an ordinance that you believe mimics the DEP regulations?
No, we have an ordinance that regulates what we believe we were able to regulate here locally.
Maybe that's a better answer to that question, so, okay. If you look at the next page, one of the thoughts were to modify the overlay district to eliminate potential areas of concerns and conflicts. Do you recall that being presented to council?
Again, this whole report was presented to council.
I'm asking, do you recall?
Through the meetings, there were discussions of the task force findings, yes.
Okay. And then there were some advantages. One was if you were to modify the overlay to eliminate areas of conflict, the advantage was with the Supreme Court decision, it is more justifiable to reduce total land area exposed to oil and gas drilling, thus reducing conflicts with compatible and sensitive land uses. You recall that, or you see that?
Yes.
And that is one of the arguments that my clients have advanced as to why this ordinance is unconstitutional. You understand that?
I do now.
And one of the disadvantages of changing to modify the overlay district that was written was to reduce remaining challenges compatibility with residential zoning areas. Now, if you look at the next one, it says eliminating the overlay district, replacing with oil and gas as conditional use in the RR district, I guess altogether, correct?
That's correct.
Can you explain to me, there are certain, well, let me ask it, there are certain parts of the rural residential district that don't allow drilling, and certain parts by overlay that do allow drilling.
That's correct.
Is the overlay, I don't wanna ask you a legal question, I'm trying to just ask what your experience was, so let me. So individuals, there could be people in the rural residential district that have different rights and different protections by way of the overlay district. Some people in the rural residential district have no fear and there's no ability in Murrysville to allow drilling on their property, correct?
There are properties within the RR district that are not in the RR, or in the overlay district, yes.
So some citizens have the protection of no drilling or the right, and some citizens have the right to drill and less protection in the same zoning district.
Yes.
Now, if you look, it says, I'm just flipping the page, it says only permitting oil and gas drilling in the business district, provided that it be located on a minimum size parcel. And I'm correct, and I think Murrysville uses business district, but essentially I can equate that to your industrial zone.
Yes.
Now, it says one of the advantages, it says the business district provides for heavy manufacturing as a conditional use, which ties in with the Supreme Court decision view of oil and gas drilling being an industrial use. You see that?
Yes.
And you understand that that is one of the arguments advanced by my clients, that drilling should happen consistent with the Supreme Court decision in the industrial zone?
No, I don't agree with that. I don't know that it's limited to the industrial zone.
My question was, you understand that the claim here, the challenge to this ordinance in question, is that it should be limited to the industrial zone because it is an industrial land
I'm gonna
use.
object. He's not here to make any determination on the nature of the challenge. And if he's actually, I'm gonna preclude him from talking about the challenge.
He either knows or he doesn't, that's all. He can say no.
No, that isn't all. He's not going to answer the question. It's a legal conclusion. Jim, you're not answering the question.
The board sustains the objection.
One of the disadvantages of drilling in the business zoning district location municipality, for the most part, located very close to residential areas, creating compatibility issues with these and more impacts. Correct?
Yes.
And that was what you testified on direct examination when we went over, when you were asked on direct, as to why you didn't, or Murrysville didn't allow drilling. There was no objection to you explaining to the board as to why it wasn't in that district. Am I correct, sir, that what Murrysville was trying to do was protect as many people as they could from a dense standpoint? If there was an area where there were 300 people versus an area of 3 people, they were gonna protect the area of 300 people. And in Murrysville, to your recollection, in any of these hearings, ever contemplate that all citizens should have equal protections? Objection. Do you recall that ever coming?
Did I get, I'm sorry, there's an objection.
I just asked him just his recollection of whether it came up at all at the hearing. Again, I don't have the transcript, so I'll bring it up if it did come up.
Can you read back his question, please?
to your recollection in any of these hearings ever contemplate all citizens should have equal protection? Was that it?
Is that the question you're objecting to?
Yes.
And I'm sorry, you're just asking him,
Does he recall whether that was something that came up with any of the public hearings? He's testified earlier about different things he recalls that they discussed, different things that were before him. That's whether that came up at all. Not whether he had any legal basis or what it is.
board overrules the objection.
I don't object to that question. It's a different question.
I'm sorry.
Even better.
He rephrased it.
Let's try that again.